to the California Lawyers Association. What an inspired choice to induct Hal Cohen into the Legal Hall of Fame. I'm Chief Justice Tani Cantil Sakaue, and I had the pleasure of learning from Hal Cohen for almost 10 years. Hal Cohen is a California Supreme Court icon. He started in 1969 with Justice Tobriner and spent 10 years with me when I became Chief Justice in 2011. Hal has served 8 justices, including 2 Chief Justices, the Honorable Ronald George and myself. Hal is a giant in the legal field, and I am so happy that he is getting his due recognition for the Hall of Fame. I can recall in this very room conversations with Hal about briefs and ideas and cases and issues and impact. We always saved some of the hardest, most complex cases for Hal, who always found a way through the legal thicket. Hal and Inez, congratulations.
Hal, it is truly a great pleasure to add my congratulations to the many well-deserved expressions of praise that you are receiving today. Hal really personifies to everyone who knew him all the skills that warrant the recognition involved in admission to the Hall of Fame. First, of course, as we all know, he has a brilliant mind and intellect. But secondly, he has a truly institutional knowledge of appellate procedure. He served really as the institutional memory of the court in terms of what happened way back when and what were the reasons and the participants in a particular decision of court procedure or substantive ruling on issue on an appeal. But perhaps most importantly of all, Hal has a truly objective insight into the fair resolution of legal disputes at the appellate level by, of course, a collegial body of several justices and many staff members involved in assisting the justices. And he always was very mindful of the practical effect of decisions being made by the court, not just as abstract legal resolutions, but in terms of the day-to-day effect on the lawyers, the legal profession, but the parties and the public. And those were really invaluable skills. And Hal was universally recognized really by the justices and the staff during the decades of service on the court as truly, truly exceptional and indispensable. I can add finally on a personal level, what a true pleasure it was for me to know Hal as an individual, to work with him, to have the benefit of his talents, to my great benefit, but the benefit of the court and the resolution of appellate issues and the effect on the public at large. So we're all very, very fortunate to have had the benefit of Hal's contributions and join in wishing him a lot of happiness and fulfillment in the years ahead. Thank you, Hal.
Well-deserved provides an accurate yet wholly inadequate description of this award to Hal Cohen, my good friend, mentor, and former double play partner on the Supreme Court softball team. The award recognizes the extraordinarily important contributions to the development of California law by a brilliant lawyer and exceedingly decent human being. Were we able to list these contributions, Hal's impact on individual opinions and the evolution of legal doctrine would impress the most discerning legal scholars. Viewed in the aggregate over a 50-year career, his effect on California law has been incalculable. I want to thank the California Lawyers Association because honoring Hal appropriately acknowledges that great lawyers are not cut from a single mold. Indirectly, but importantly, this award recognizes the efforts of the countless research attorneys and law clerks who work in California's state and federal courts. Although these lawyers write anonymously under the names of different judges and justices, their work product reflects their profound individual commitment to the courts as an institution and the fair administration of justice. It is a commitment so thoroughly and admirably exemplified by the career of Hal Cohen. Congratulations, Hal.
Good evening. My wife and I have recently moved to the East Coast to be closer to our children and grandchildren, so I appreciate the opportunity to speak to you remotely. At the outset, I want to thank the Committee on Appellate Courts and the California Lawyers Association for selecting me for this honor. Chief Justice George, Chief Justice Cantel Sakaway, and Justice Dato for submitting very generous letters of support to the committee on my behalf, and my colleague, Greg Wolf, for proposing my nomination. I am very humbled, but also very proud to accept this honor, not only given the extremely accomplished appellate lawyers who previously have been chosen for this honor, but also because I realize that I am accepting this recognition on behalf of all of the appellate judicial attorneys in California who have followed a similar career path. These judicial attorneys, working in both the California Court of Appeal and the California Supreme Court, are most often not known to other appellate lawyers or to the public, but they perform an incredibly important role in California's judicial system and generally do not receive the recognition they deserve. Because my career as an appellate judicial attorney differed from those of the prior recipients of this honor, who work largely in the private sector, I thought I would share a few personal thoughts regarding some of the challenges and the rewards of the work of an appellate judicial attorney in California, and particularly of those who are lucky enough to work at the California Supreme Court. There are a number of challenges that are largely unique to judicial appellate attorneys. First, at the California Supreme Court, chamber attorneys must endure the rigorous gauntlet of the Supreme Court's preliminary review PR process. In most legal positions, one's work is typically reviewed by at most one or two colleagues, but at the Supreme Court, calendar memos, that is, draft preliminary opinions circulated prior to oral argument on which a chamber's attorney has labored often for weeks or for months, are subject to the vigorous review of 6 other judicial staffs, each of which prepares a PR that is circulated throughout the court, containing detailed comments, suggested changes, and penetrating critiques, frequently running 10 or more pages. In my view, the PR process, without question, plays a big part in ensuring a high quality of the court's ultimate opinions. But it is always stressful and humbling to have the drafts you have worked so long to perfect put before the critical eye of generally kind but always demanding colleagues. Second, as an effective collaborative ghostwriter, I needed to attempt to adjust to the distinct writing style of each of the justices I worked with. Given the length of my tenure at the court, I had to learn and attempt to accommodate the very different writing styles and idiosyncrasies of 8 justices. The first justice I worked with, Matt Tobrina, was quite comfortable with lengthy opinions, with long sentences and extended paragraphs. Indeed, one Court of Appeal justice was said to have remarked somewhat playfully that, quote, "It takes Matt Tobrina 14 pages simply to clear his throat," unquote. I must admit that I suffer from the same affliction, and many of the justices I have worked with since my time with Justice Tobrina have continually been burdened with editing long sentences and lengthy paragraphs, frequently pressing me to break up my initially drafted sentences into 3 or more easily digestible segments. Third, because of the confidential nature of a judicial attorney's work, continuing even after an opinion one has worked on has been published, one cannot, or at least should not, discuss one's work publicly with those outside the court. The consequence is that, at most social occasions, I found myself in a constrained and not very interesting or satisfying position, even with close friends. Although it was possible to share publicly available information about cases pending before the court, I could not disclose what cases I was personally working on or had worked on, or reveal the back and forth that is so much a part of the appellate deliberative process, and that those outside the court were naturally most interested to learn. Fourth, and this is particularly challenging for one who has spent his or whole career as a judicial attorney, I cannot reveal to others a compendium of my life's work. All the hundreds of cases I have contributed to, including the ones of which I am most proud, must remain confidential. In retrospect, however, there is no question that the challenges posed by the job are greatly outweighed by the rewards of working as a judicial attorney at the California Supreme Court. First, of course, is the importance of the work itself. At the Supreme Court, one is always aware that you are making a very direct contribution to the formulation and evolution of California law. There is immense satisfaction in knowing your work is making a difference and in playing an important part in advancing the cause of justice. Second, the work is invariably intellectually stimulating. Particularly at the Supreme Court level, the cases which the court chooses to hear almost always present difficult legal issues, often questions on which lower appellate courts have reached differing legal conclusions. For me, it was incredibly satisfying to have the luxury and freedom from billable hours, to be able to take the time to deeply research the history and background of a sometimes esoteric legal rule, and to compare California's treatment of the subject with the treatment in other states, in the federal system, or at times in other countries or under international law. And at the Supreme Court, a chamber's attorney's work is not limited to a particular subject matter or even to civil or criminal cases in general. Rather, I had the opportunity throughout my many years at the court to continually confront entirely new areas of the law and to compare the evolution of rules in very different settings. For example, from constitutional cases dealing with freedom of speech and racial discrimination to novel tort, contract, or inverse condemnation disputes. The variety assured that I was always delving into new fields and learning new legal history and concepts. Third, the monastic-like academic environment of appellate work in a judicial setting suited me. One scene in a movie I recently saw for the second time reminded me of an important part of what I loved about my work. The movie was an Israeli film, The Footnote, about a father and son, both Talmudic scholars who were each considered for the same prestigious award. The scene in question showed the son descending into the bowels of a large library to find his father at his father's workplace in the library's basement, and discovering his father celebrating his perceived success with colleagues. I too spent hours in the court's library, which, truth to tell, in recent years I had mostly to myself, as younger colleagues did all their research online. And I remember well the joy of finally finding, after hours of research through piles of bound volumes, the one passage that perfectly captured the thought, analysis, or explanation that had been rattling around in my head, but had previously eluded my tangible expression. Finally, perhaps the most significant reward of my work at the Supreme Court was the wonderful and warm relationships I developed with each of the justices with whom I worked, with the other justices on the court, and most especially with the colleagues on our own staff and on the staffs of other justices. In this respect, the culture of the California Supreme Court is much different than that of other appellate courts with which I am familiar, where appellate judges or justices do not encourage, or sometimes do not even permit, their chamber attorneys to confer and share ideas with the staffs of other judges on the panel. The California Supreme Court's culture very much encouraged the sharing of ideas and dilemmas with all the court's attorneys. Some of my best and most productive times were spent discussing and debating, often, I must admit, at a volume that at times alarmed neighboring office mates, the difficult issues in the case that I or the other attorney was working on. It was the loss of the opportunity for such face-to-face discussions during the COVID pandemic that ultimately led me to decide that, after more than 50 years at the court, it was time to fully retire. As I look back, my many years at the Supreme Court resulted in a terrific, most fulfilling career for which I will always be tremendously grateful. I thank all the justices with whom I worked and all the judicial attorneys with whom I have had the privilege to serve. And again, I thank the committee for the great honor of this recognition of my work at the court. Thank you.